So this video is here to talk a little bit about letters of administration or letters testamentary and the probate process. If a bank or financial institution tells you that you need letters of administration or letters testamentary, what that means is that the account that they are holding does not have beneficiaries listed on it and the account holder is deceased. In order for you to have access to that account, either to pay off creditors, to distribute it to where it's going next, they need to be presented with a document called letters of administration or letters testamentary. The name is a bit misguiding because something like a letter sounds like something an attorney can type up and hand right back to you. Unfortunately, that's not the case. Letters are a court order that can only be granted by the judge after following a very detailed procedure. That procedure is the establishment of a petition filed with a court, scheduling a court hearing, and within that time, sending out a notice to all known heirs and beneficiaries of the estate. So every heir needs to be found, and those would be the biological survivors as defined by Kansas statute. So it's usually all children of a decedent, the spouse, and if there are no spouse and children, it would be the parents, siblings, grandparents, aunts and uncles, cousins. A search needs to be done to figure out who are the surviving heirs and who would receive the property, and to find all the beneficiaries of the will to give them a chance to be notified of the petition and to have yourself appointed as executor. In order for a court to grant letters testamentary, what that means is that it's an order that the court gives designating someone as the executor or administrator of an estate. And that is the person who is designated to act on behalf of the estate, who can stand in the shoes of the decedent to wind up their affairs, pay their taxes, carry out all the tasks that need done. A bank is not permitted to give that money to just anyone, so they need to see the court order in hand. In order to get that court order, it's not a simple matter of an attorney writing a letter that says this person can access the money. Unfortunately, it's a bit more complicated than that. There's a very detailed procedure that has to be followed in order for the court to eventually grant letters to an executor or administrator. That procedure is that after filing a petition drafted by an attorney, a court hearing is set, and sometimes that court hearing could be as much as a month out, in which a publication might be published in a local newspaper announcing the death of the decedent and notifying of the court hearing, proposing to appoint someone as the administrator or executor. And then official notice needs to be given to all of the heirs at law, which would be the surviving family members who would be next in line to receive property, and all of the beneficiaries under the will, if there is a will. All of those people need to be notified. If there are minor beneficiaries, an attorney needs to be appointed to represent their interests. If there are unknown heirs, unlocatable parties, if there are minor beneficiaries or disabled heirs, an attorney, a separate attorney, needs to be appointed to represent their interests through the whole process and receive notice on their behalf. After the period lapses and the hearing is held, all of those parties are notified that they're given a chance to object to your petition to open the estate and appoint yourself as executor. And as long as no one objects and the judge agrees with the appointment, they will then issue an order designating you as the executor or administrator, and then grant you letters of administration. And the granting of the letters is only the beginning of the probate procedure. Anyone who is appointed has a series of tasks and responsibilities and duties that they have to accomplish with a certain amount of time. The probate attorney is there to guide you through those steps and procedures, but once those letters are issued, that is when you can turn around and finally go back to the bank to take that money. And you still don't have full access to the money. It means you have the authority to close the account and deposit the proceeds into an estate account. The actual distribution of that account to whoever it's going might take another 6 months to a year worth of procedure before you are legally permitted to distribute it to the heirs and beneficiaries. If a financial institution tells you that you need letters of administration or testamentary, what that tells me is that there's an account that they're holding from a person who is deceased that does not have beneficiaries listed on it, which means that there's no one legally in place already to designate where that property can be distributed. The laws state that the only person who can then access it next is the duly appointed executor or administrator of the estate. This is a safety precaution that keeps anyone off the street from coming in and claiming the money who's not legally entitled to it. And so there is a procedure established which is meant to just prove up that you are who you say you are. You actually are entitled to go access the money. And when they tell you that they need letters testamentary, they don't necessarily need it. It just means that there are no beneficiaries on that account, and therefore they can only talk to an executor or administrator. However, in Kansas, if the total amount of assets that don't have beneficiaries on it is less than $75,000, there is a rule that says that instead of going through a big, long court procedure, a simple worksheet can be submitted to that institution that lists who is entitled to the property and how to cut the checks. If the total amount of accounts, not just the account at that bank, but the total amount of accounts that don't have beneficiaries on them, is more than $75,000, that does require probate. But generally speaking, if those accounts are worth more than $75,000, that worksheet won't be applicable, and you do in fact need to go through the steps of a full probate procedure. Now, in order to get those letters of administration or testamentary, which means in order to have a judge appoint you as the executor or administrator of an estate, we have to go through procedure, which you'll want an attorney for. It's a very complicated procedure. That procedure requires the filing of a petition with the court and establishing a hearing. And before that hearing, you're duty bound to notify all heirs at law, all beneficiaries under the will, and all other interested parties to the estate to give them a chance to object to your petition proposing to have you appointed. If and only if you followed the proper procedure, notified all the proper parties, and submitted the filings within the proper times, the judge has the choice to appoint you as the executor or administrator. Once the judge issues those letters is only the beginning of the probate process.